All right, welcome to this High Yield Explainer. Our goal here is to make you an expert on the legal and ethical challenges in psychiatric nursing. We're going to skip all the fluff and get right to the safety-critical information that you absolutely have to know. Okay, let's just dive right in with this core dilemma. This question really gets to the heart of that constant balancing act between a patient's rights and public safety. We're going to break down the answer and the principles behind it, starting with exactly how and why a patient even enters the system against their will in the first place. And this is the very first stop on our patient's legal journey, civil commitment. That's the formal legal process for admitting someone to psychiatric care when they don't agree to it. And look, understanding this is absolutely non-negotiable for safe practice. So on our virtual whiteboard, I really want you to picture the classic scales of justice. On one side, let's put the patient's fundamental right to autonomy, the right to say no to treatment. And on the other side, we have the state's duty to protect its citizens. There's a legal concept for this, parens patriae, which literally means parent of the nation. The whole world of mental health law is all about balancing these two heavyweights. So how do those scales actually tip towards intervention? Well, it only happens when a patient meets at least one of these three very strict legal criteria. They have to pose an imminent danger to themselves, an imminent danger to others, or they're considered gravely disabled. And that just means their mental illness is so severe they can't provide for their own basic needs. Things like food, clothing, and shelter. Let's talk communication for a second. Saying something like this, it's not just therapeutically wrong, it's legally incorrect. It just creates this awful sense of punishment and stigma. So here's the crucial point. Civil commitment is part of civil law. It's for medical protection. It's not criminal law. It is never, ever a punishment.
And now this is how you do it. This is the right approach. First, you validate their feelings. Who wouldn't be frustrated in that situation? Then you pivot into your role as an educator and an advocate. You're explaining what's happening, you're setting expectations, and you're reinforcing that your goal is to help, not to punish.
Okay, time for a classic professor's trap. This is the kind of scenario that's specifically designed to test if you really understand the big three criteria we just talked about. So you have a patient with a serious diagnosis, they're actively symptomatic, but is that enough on its own to justify an involuntary hold? The answer is a clear no. And this is a huge takeaway. A diagnosis or even the presence of symptoms, like hallucinations, is not enough. There has to be a specific, observable, and dangerous behavior or a real inability for self-care. This patient is calm and they're meeting a basic need. They do not meet the legal criteria. All right, let's move to our next section and see how this all builds. So, once a patient is admitted and a crisis kicks off, how do we manage that immediate risk to keep everyone safe? Well, this brings us to the very highly regulated interventions of restraints and seclusion. I want you to visualize this concept as an escalation staircase. We always start at the bottom step with the least restrictive options. That means using our words, our therapeutic relationship, maybe offering to redirect them, or just reducing stimuli in the room. We only climb those stairs to the more restrictive options, like seclusion and restraints at the very top, as an absolute last resort when there's an immediate, right-now threat of harm. Okay, pay very close attention to this slide because this is where legal precision is just absolutely critical. The law is incredibly specific about these time limits for good reason, patient safety. For adults, the limit is 4 hours. For adolescents ages 9 to 17, that drops to 2 hours. And for a child under 9, it's just 1 hour. These are hard stops that require a complete reassessment.
These next two are non-negotiable safety rules. First, you never, ever, ever use the prone position for a restraint. The risk of positional asphyxiation is just way too high. And second, you never administer medication covertly, like hiding it in their food. That completely violates trust and the patient's rights, unless it's a very specific, documented, life-threatening emergency.
So far, we've been pretty reactive, right? We're responding to crises as they happen. Let's switch gears and talk about a proactive strategy. How can we empower our patients while they're stable to actually plan for future crises and hang on to their autonomy? The answer is something called a Psychiatric Advance Directive, or PAD. Here's another great visual metaphor to help this stick. Think of the Psychiatric Advance Directive as the blueprint. The patient creates it when they're well, and it outlines their exact wishes for treatment if a crisis happens later. Then, the healthcare proxy is the project manager.
That's the person the patient trusts to step in and execute that blueprint if and only if they become unable to make decisions for themselves.
And here we go, another professor's trap that shows up all the time on exams. A patient signs the legal paperwork, they appoint a proxy. So, does that proxy now get to call all the shots? When does their authority actually kick in? So here's the key. Signing the document changes absolutely nothing in the present moment. The patient keeps 100% of their autonomy. The proxy's power is only activated when a clinical determination is made that the patient lacks the capacity to make their own healthcare decisions. Until then, that proxy is just on standby. Now, this slide, this number, reveals a pretty startling gap between the theory and what's actually happening out there. Even though these documents are so empowering, only about 26% of people have any kind of advance directive. This just highlights a massive opportunity, and frankly, a responsibility for us as nurses to educate and advocate for our patients to get these done. Okay, let's move into our final content section. This one deals with the most profound loss of autonomy a patient can face, the formal legal decision that they are no longer able to make their own decisions. This is the world of competency and guardianship. Let's use one last analogy here. The patient is always the captain of their own ship, right? They steer their life, they steer their healthcare. But if a severe mental illness means they can no longer steer safely, the court can appoint a navigator, a legal guardian to take the wheel and make decisions to keep the ship from sinking. And this slide right here brilliantly illustrates one of the most frequently tested distinctions in all of mental health law: capacity. That's a clinical determination. It's made by us, by healthcare providers at the bedside. We assess it every single day. But competency, that is a legal determination, and it can only be made by a judge in a court of law. So a doctor can say a patient lacks capacity, but only a judge can rule they are legally incompetent. So when a guardian is involved, your role as an advocate gets dialed up to 11. You have to always be monitoring for signs of financial or personal exploitation. And remember this: even if a patient is legally incompetent, the guardian must still provide informed legal consent for any new non-emergency medications. Okay, let's put all of this together. It's time to apply these principles in a next-generation style clinical scenario. You're the nurse, and you have to decide what the priority action is. Okay, let's break down the keys here. You've got an involuntarily admitted patient, which tells us the danger to self or others criteria has already been met. You're seeing clear, nonverbal cues of escalation, the pacing, the clenched fists. And then you have a direct refusal of medication, which, even on a hold, is their right in a non-emergency. So here's the final question for you to really think about. Thinking back to our escalation staircase and the principles of least restrictive intervention and therapeutic communication, what do you do first? What is your priority nursing action to ensure the safety of this patient and everyone else on the unit? Give it some thought.